I am delighted to say a few words as we have a assembled group of students, some of whom are finding their way through appellate advocacy for the first time. Others before you are our most accomplished and are refining a craft that they'll continue to work on. I predict you will all learn to love this form. There are people in the audience who fell in love with it while in law school, who are finalists, and are now doing amazing things in our profession. A request that I would offer now, which Chris McKee will repeat at the end, all of you in our community, if you can make an effort afterwards to visit with our students. The students here are really grappling with what it means to be a lawyer, what it means to be an appellate advocate, and today we'll have a master class as we have 3 judges who are all exceptional, all of whom, in my view, are at the very, very highest caliber. We're so thrilled to have them. The Judge Ray Rothgerber from the 2nd Circuit, Judge Stephanie Seymour from the 10th Circuit, and our own Judge Neil Gorsuch, also from the 10th Circuit, but more importantly for us, an adjunct professor on this faculty. So we're very excited to have them. I will turn things over to our bailiff momentarily, but a few words before I do so. First, on experiential learning, competition program, and our new director, Chris McKee. For those of you who have yet to meet Chris, I assure you, you will deeply appreciate his wisdom, experience, and commitment to your development. His focus on experiential learning and public service are a core part of what we're about here at Colorado Law. Over the 3 years that students are spending here, we had a range of experiences, many of which you're going to treasure and think back on. For many people who do competitions and who do public service, who get to work with Chris, we're extremely lucky to have him. We have a number of faculty members who are here with us today. Let me only mention one of them who's been overseeing this effort, and that's our amazing associate dean, Helen Norton, who cares deeply about this effort and development of all the students in this building. Those of you who have the pleasure of taking the class get to benefit more directly, but everyone in this building, teacher and like, indirectly benefit. So hats off to Helen and to Chris for their leadership. So without me taking any further ado, I want to thank you guys all so much for coming. At the end, we're going to have Chris take the floor for the teachable moments from today's oral argument. And without further ado, I will turn over to our bailiff du jour. I think Anna is somewhere around here, right? Where's our bailiff? Our bailiff is going to take over. For those who remember watching People's Court, everything as a bailiff. They'll take it away.
All rise. The Supreme Court of the United States is now in session. The Honorable Justices, Judge Gorsuch, Judge Seymour, and Judge Loye presiding. You may sit down. The case before the court is Janice versus the United States. The petitioner and the respondent are each allocated 30 minutes. Would a representative from the petitioner please inform me how much time they would like to allocate for rebuttal? 2 minutes, please.
Good afternoon. We ready to begin? Hear the petitioner.
Madam Chief Justice, may it please the court. My name is Leah Gould, and along with my co-counsel, Tyler Marcher, I represent the petitioner, Mr. George Janice. I'd like to reserve 2 minutes of our time for my rebuttal. I will be arguing that the question about Mr. Janice's connection to the cell phone fell outside the routine booking exception and should be suppressed. Mr. Bosher will be arguing that the act of decryption and production is testimonial in nature and protected by the privilege against self-incrimination. The standard of review for both issues is de novo. This court should reverse the 14th Circuit and suppress the question regarding Mr. Janice's connection to the cell phone for 3 reasons. First, the question was not reasonably related to an administrative concern of law enforcement. Second, Officer Aronson knew or should have known that asking Mr. Janice whether he owned the phone was reasonably likely to elicit an incriminating response. And finally, expanding the routine booking exception to include potentially incriminating questions risks improperly broadening custodial interrogation. As to my first point, the question was not reasonably related to an administrative concern of law enforcement. In Munich, Justice Brennan rejected Pennsylvania's claim that biographical questions do not qualify as interrogation merely because the questions were not intended to elicit incriminating responses, but rather the plurality held that the questions are nonetheless admissible because they fall within a routine booking exception, which exempts from Miranda's coverage questions to secure biographical data necessary for the booking and pretrial services.
What kind of test would we use to decide? You want us to limit it to biographical information, which is the only thing we've talked about so far. Why should we do that? Why isn't it a good idea to ask somebody who's possessing a phone if it's his?
Well, Your Honor, when this court in Rhode Island v. Innis expanded custodial interrogation from Miranda to not only include direct questions, but also statements or questions that have a reasonably likelihood of eliciting an incriminating response, those types of statements or questions should be excluded from the routine booking exception.
Why is there a reasonable likelihood of eliciting an incriminating response when the only question is this your cell phone? Cell phones and other property have got to be vouchered, is that correct?
Yes, Your Honor.
And so what is the police to do when they have a cell phone, pocket trash, documents that are in someone's pocket and so on? What are they supposed to do with that property?
Police can still inventory that type of property without determining the owner of that type of property.
Well, what if the inventory form said, I hereby acknowledge that these materials are mine and you may hold them for safekeeping, as I suspect most forms do. Is that a problem, Ms. Gould?
It depends, Your Honor. For example, the Sixth Circuit in the United States v. Cole determined that a police officer asking whose gun is this constituted.
No, that wasn't my hypothetical, though, was it?
No, Your Honor.
So why don't you answer my hypothetical?
Yes, Your Honor. It really does depend, and most circuits, including the First, Second, Fifth, Seventh, Ninth, and 11th circuits, have all conducted a totality of circumstances analysis to determine whether a question falls outside.
And so my question is, this is the totality of the circumstances. There's a form. I hereby acknowledge that the materials in this bin are mine, and you may hold them for safekeeping. Signature, defendant.
In that case, Your Honor, it may be appropriate. However, in this case,
Okay, if that's appropriate, then what's the difference between that form and what happened here, which was just an oral question rather than a written one?
what happened here, Your Honor, is you have a police officer with 10 years of experience with the narcotics division who should know the importance of a cell phone to someone who is suspected of running a drug operation.
But let's keep it to the hypothetical, which is it's a routine, it's a booking question, it's a routine question. Whether it appears on a voucher form or whether it's asked by Officer Aronson in this case shouldn't matter, should it? And if it does, if your position is that it should matter, why should it matter?
This court should err on the side of caution when it comes to a question constituting custodial interrogation, because unwarned statements, which may be voluntary, must nonetheless be excluded when they do constitute.
No, but having told us that it may be okay to have a question on a voucher, a document that in essence requires a defendant to say this is my property for vouchering purposes or for whatever other purpose, why is that different from what happened here in effect?
Well, Your Honor,
Unless you're telling us that it's the wrong test and that you can't prevail under the first test, but you might be able to prevail under an objective test or a subjective test.
petitioner prevails on both an objective and subjective test here, Your Honor. The Second Circuit in Lavallee held that even questions that are part of the routine booking exception which may seem non-incriminatory in character may nonetheless be incriminating in certain circumstances. So by keeping the routine booking exception narrow to the 7 questions that the plurality recognized in Muniz, then going beyond those questions enters the territory of custodial interrogation.
Is there anything in the record that indicates that the question about the cell phone was not part of this department's ordinary booking process?
Unfortunately, Your Honor, the record is silent.
And isn't that your burden to show that somehow it deviated from the ordinary booking process?
Yes, Your Honor.
But the district court didn't give anybody any chance to put on any evidence, did it?
No, Your Honor.
In fact, he gave pretty short shrift to this question.
Yes, Your Honor.
So what do we do about that if we don't know what the facts really are?
This court should look to the purpose of the routine booking exception. If the purpose of the routine booking exception is to identify the person in custody, identifying the person in custody's property goes beyond that routine booking exception. This is a narrow exception that cannot be expanded so that it swallows the rule. Instead, expanding the routine booking exception to include potentially incriminating questions and their responses weakens Miranda by potentially allowing police officers to circumvent it.
What was potentially incriminating about this question to the RICO charge that the defendant was ultimately pled guilty to?
Your Honor, the problem here was that the police hoped to connect Mr. Janis to the cell phone so that they can connect Mr. Janis to the data on it. And they wanted to put the data on the cell phone in the drug charge that they brought against.
There was a sticker on the cell phone that identified the cell phone as being the property of the auto body shop. Is that right? The Greased Monkey?
Yes, Your Honor.
Unusual name, but we'll take it. What if the Officer Aronson had asked, do you work at the Greased Monkey auto shop? Would that have been a problem in your view?
Yes, Your Honor. Because that question goes beyond the normal routine booking exception questions, which are name, address, height, weight, eye color, date of birth, and current age. Questions that go beyond those, that go beyond identifying the person in custody so that the police can verify that they have the correct person in custody, go into the territory of potentially incriminating questions.
Now, Ms. Gould, just to return to our hypothetical and the voucher. You say the difference is that, you started to say that the difference between the voucher question and an officer asking the question was that we're talking about a 10-year sophisticated narcotics investigator who knew the potential importance of a cell phone in narcotics operations. Is that right?
Yes.
So is your argument really that the proper test should be the intent of the officer asking the question? So the voucher form, we intend only to protect property interests, no problem. The officer asking the question, different kettle of fish because of his intention. Is that your argument?
No, Your Honor. In fact, this court in Innis, in footnote 7, stated that the subjective intent of an officer is relevant but not dispositive. Rather, the rule is the objective test, that the police officer should have known that the question was reasonably likely to elicit an incriminating response. And so, regardless of whether Officer Aronson had actual knowledge that Mr. Janis might incriminate himself, it doesn't matter. The question must still be suppressed because it had a reasonable likelihood.
So you're saying that the legitimate administrative purpose test is inappropriate?
Yes, Your Honor. Whether
Doesn't that come directly from Muniz? Doesn't that language come directly from our prior precedent?
Yes, Your
So are you asking us to overrule our prior precedent in Muniz?
No, Your Honor. I'm asking this court to distinguish that a question regarding Mr. Janis's ownership of the cell phone goes beyond the questions that are normally attended to arrest and custody.
Well, but we just agreed, though, I thought, that it isn't an abnormal question when it's in the voucher, right?
No, Your Honor. It is an abnormal question when it's...
Oh, so it's abnormal for the police to ask, is this your property, when you're submitting it for safekeeping? Is that your position, and do we have any evidence to that effect?
In this case, it was the cell phone was found on Mr. Janis's person, in a search incident to arrest. Mm-hmm. The government points to the case of Alford v. State, in which a flash drive was found under the patrol car's seat. after the defendant had been removed from the patrol car. And the Texas Criminal Court of Appeals.
Do we care what the Texas Court of Criminal Appeals held? No, okay. All right, so how about my question, Ms. Gould? All right. If the test is an objective one, right, what's wrong with, if it's okay on the form, why can't an officer ask the same thing orally? If you're saying it's not okay on the form, do we have any evidence that that's not reasonably related to a normal police function? Asking, is this your property you'd like us, that we're going to take for safekeeping while you're in custody?
Yes, Your Honor. It's not reasonable for that question to be on the form because police can easily inventory items without determining the proper owner. Police do not need to determine who owns the things found on a person's person.
What if Mr. Janus asked for his property back? I mean, there's a reason we've got a vouchering system in this country. In every little hamlet, it's in the event that someone who's been arrested and who's released either that day or 10 years later wants the property back, we have some system of knowing that this belongs to you. There are Rule 32 motions in the federal context pursuant to which someone can request their move to get their property back. Wouldn't that, what you're proposing, wouldn't that entail a breakdown of that system?
No, Your Honor. This court has held in Burdine that an inventory search is completely reasonable so long as police are following the protocol, and that is for the safety of the police officers. However, in this case, because Officer Aronson should have known that asking about who owns the cell phone went beyond the inventory search or the search incident to arrest.
What if that question were unrelated to the substance of the offense with which Mr. Janus was charged?
That also occurred in the Texas Criminal Court of Appeals case of Alfred v. State, in which the flash drive found was not intended to be used against the defendant. And so that is another consideration that the court made in allowing that question to be included in their routine booking exception. However, here, because in the totality of the circumstances, a cell phone is important to prosecuting a drug operation case, then here this court should err on the side of caution and suppress the question and response.
So is your position essentially that when it comes to routine booking, you may need to acknowledge that this is the stuff found on me, but not necessarily that it belongs to me?
Yes, Your Honor. That is petitioner's position.
But don't we have a particular problem here because the phone actually says with a sticker on the back that it may belong to somebody else?
No, Your Honor. That should not affect this court's analysis. I see my time has elapsed. May I briefly conclude? And for those reasons, Your Honor, this court should reverse the 14th Circuit and suppress the question and answer. Thank you.
Thank you.
Madam Chief Justice, and may it please the court, I'm Tyler Boschert, representing petitioner George Janus. This court should reverse the decision of the 14th Circuit, quash the subpoena ducis tecum, and hold that Mr. Janus's act of decryption and production would be testimonial in nature and therefore covered by the Fifth Amendment privilege against self-incrimination. This court should so hold for three reasons. First, Mr. Janus would be required to use the contents of his mind and implicitly convey a statement of fact in order to comply with the subpoena. Second, the government has not proven all that it must prove to invoke the foregone conclusion doctrine. And third, the privilege against self-incrimination is not and should not be subjected to the balancing test the government favors. Turning to my first point, Mr. Janus would have to use the contents of his mind and implicitly convey a statement of fact to comply with the subpoena. In 1976, this court outlined the foregone conclusion doctrine in Fisher when it held that the production of documents in that case was not protected by the privilege against self-incrimination. But even so, the court stated that compliance with a subpoena tacitly concedes possession or control by the witness of the things produced. So it's been settled Supreme Court precedent for nearly 40 years that an act of production in and of itself, separate from the contents of what is produced, may have some testimonial character of its own. And in Fisher, the court also made clear that the question of whether a particular act is testimonial is very fact-specific, and we can't make a bright-line rule about what is and is not testimonial. We must examine the facts of any particular case. That was reiterated in Hubble 14 years ago. In that case, the court held that where a prosecutor needs the defendant's assistance, both to identify potential sources of information and to produce those sources, the collection and production of those materials is tantamount to answering a series of
This is a
interrogatories.
slightly different scenario from the scenario that existed in Mr. Hubble's case, Webb Hubble's case. Here, I'm a little hard put to see how there's a fishing expedition of the sort that we were concerned about in Hubble. You've got a laptop, and there's no dispute, correct, that it belongs to Mr. Janus?
There is dispute about that.
There was some dispute about
There
that,
is.
okay. But that was not the subject of a motion to suppress.
No.
The laptop, unlike the cell phone, is that correct?
That's correct, Your Honor.
And there is an effort to go through all the files and a determination that none of the files fit the description that was provided by Mr. Peters, who's a corroborated cooperator, correct?
That's correct.
And so there's one encrypted file called business materials. And it seems to me that we're not talking about a fishing expedition. The government has identified the specific fish underneath the ice and is just asking to get at the fish. So why isn't it a foregone conclusion under those circumstances? And
Well-
why is this even remotely close to Hubble?
Well, to extend your metaphor a bit, Your Honor, the court is claims that it is only seeking the fish, but what it neglects to point out is that the government has not established with reasonable particularity that Mr. Janus is capable of breaking through the ice.
Do you have any problem with the reasonable particularity test?
No, Your Honor.
Do you embrace that?
Yes, the reasonable particularity test is what was set out in Hubble, and that's the test that should be used for establishing the foregone conclusion. Yes, Your Honor. So while I agree that the sort of egregious nature of the fishing expedition in Hubble, what the government has tried to do here, it doesn't rise to that same level.
What else does the government need to do to tell you that this is the fish that we're looking for
What the government,
in this case?
What the government must do to establish the foregone conclusion doctrine in this case is to introduce facts into the record showing that Mr. Janus either owns or has exclusive control and possession of this laptop.
On
Is there an
that,
inference?
I'm sorry, Your Honor?
Isn't there an inference of that? He had it in the car, he threw it in the back seat. We know he owns a laptop from the informant.
Your Honor, this court should not make an inferential leap that would fill an evidentiary gap in the government's case. The 11th Circuit held in 2011 subpoena that merely because the hard drives that were the subject of the subpoena in that case were found in the defendant's hotel room, that was not sufficient to show that the defendant had exclusive possession or control over those files or that he was capable of decrypting those files. So mere physical possession of the media on which encrypted files are found is not enough to establish the foregone conclusion doctrine. The government hasn't established any link between either Mr. Janus's recording of documents pertaining to a drug smuggling operation or from Mr. Peters' testimony to the particular laptop in question in this case.
So your position is that the government has no probable cause in this case? It must be.
Yes, Your Honor. I would say that the government has not shown with reasonable particularity every step along the way.
No, it's got no probable cause in this case to believe anything about this, the contents of this laptop.
The government may have cause to believe that something of the nature of which Mr. Peters has given information may be on the laptop, but there isn't enough information here to satisfy what's necessary to invoke the foregone.
Counsel, did you just acknowledge that there was reason for the government to believe that the material on the laptop was his?
No, Your Honor. So what the government
I must have misunderstood. What did you just say then?
What the government may have reason to believe is that Mr. Janus recorded information on a laptop.
Oh, okay. From Mr. Peters.
From Mr. Peters, that's correct.
Okay, so we have some belief that a laptop has information on it connected to the drug trafficking trade.
On the basis of Mr. Peters' testimony, yes. Your
Okay,
Honor.
so you've conceded that. And then you'll concede as well, I believe, that your client was caught with a laptop at the time of the arrest.
The laptop was in his vehicle when he was arrested, yes.
And there's no evidence that the laptop that was in his possession might belong to anyone else.
There's no evidence either way as to who may own the laptop in question in this instance, Your Honor.
Beyond the fact of his possession.
That's correct, Your Honor.
And
but-
beyond the fact that Mr. Peters testified that he has a laptop.
That's correct, Your Honor, but that's precisely on point with the decision in the 2011 subpoena case. Just because a defendant has physical possession of the media on which encrypted files are found, even if the government has obtained those media on information that they've obtained by legitimate means, which was the case in 2011 subpoena, those facts aren't enough to establish with reasonable particularity that the defendant can decrypt particular files on those media. There has to be shown with reasonable particularity control and ability to decrypt the particular files at issue.
Does the government have to prove reasonable particularity beyond a reasonable doubt at this stage in the proceedings?
At this stage in proceedings, no.
So what
Beyond
standard do they have to show reasonable particularity?
I would say that reasonable particularity would be a preponderance of the evidence.
Preponderance of the evidence?
Yes, Your Honor.
Okay. So what evidence, that means 50-50, right? What's on your side of the ledger? We have Mr. Peters' uncontested testimony that there is a laptop involved in the drug trafficking trade. We have a laptop that was caught on the defendant at the time. And in fact, the mere fact that the business materials, as they're labeled, a file, is encrypted, doesn't that maybe suggest that the defendant doesn't wish people to see what's in those, which itself might lead to an inference that there's something nefarious in them? What do we have? So that's on the government's side of the ledger. Help me. I need some help on what's on your side of the ledger.
I would suggest, Your Honor, that the fact that the file is labeled business materials actually cuts in both directions. So the fact that it's encrypted may indicate that somebody wishes to keep those files hidden from somebody who doesn't have access to them. That doesn't necessarily evince any criminal content in those files.
But it suggests an intention to hide.
Certainly, Your Honor. But the fact that it's labeled a business materials file is merely reflective of the fact that Mr. Janus runs a legitimate business, namely the automotive shop in this case. Mr. Janus also has employees in his business. And so the fact that
the personal items that were on the laptop were not encrypted, and are not sufficiently important, but the business materials are sufficiently important to encrypt.
Well, Your Honor, the unencrypted files on the laptop, there's no evidence in the record as to who those files belong to. Officer Aronson's report merely states that there's nothing in the unencrypted files to tie Mr. Janus to any sort of drug smuggling operation. But the officer's report doesn't actually say that those files belong to Mr. Janus.
They say that they include calendars showing meeting times, I believe. No, well, that might be. I'm looking at the record, page 16, counsel. Maybe you can help me. What do we know about what was found unencrypted here?
We know very little about what was found unencrypted here, Your Honor. And one of the things we don't know is whose files those.
What do we know, though, counsel?
We know that there are some pictures, that there are emails, that there are calendar entries that are unencrypted, and we know that none of those files tie Mr. Janus to a drug smuggler.
We know that they're Mr. Janus's materials.
We do not, Your Honor. So where Mr. Janus owns and operates a business, he has employees. The business materials file may be within the access or control of any number of people who are involved in the running of that business. And that's further evinced by the fact that when you run a small business, the assets of the business and your own personal assets may get commingled. That happens frequently. And so the mere fact that the laptop in this case was found in Mr. Janus's car is not sufficient to establish with reasonable particularity that he is able to decrypt the business materials.
No, but he's not being asked to decrypt. He's being asked to produce the document.
Yes, Your Honor, but
isn't there a difference there?
No, Your Honor. Implicit in the subpoena is a requirement that Mr. Janus decrypt and produce the file. So if he does not decrypt and produce the file, then he's running afoul of the subpoena. If he does decrypt and produce the file, he is tacitly admitting that he is capable of decrypting the file, which suggests that he may have decrypted the file before, that he may have created it, that he may have accessed it. The government hasn't shown any facts which would establish those things in this case. So Mr. James.
Government argues that the defendant is not being required to disclose anything that's in his mind.
Your Honor, this court in Hubble characterized that view of Mr. Janus's act, that view of the defendant in Hubble's act of decryption and production as anemic and as failing to account for reality. The government can't merely say, well, we're not actually looking for a combination to the safe. We're looking for the documents in the safe. The court in Hubble flatly rejected that line of reasoning and said that where a witness would implicitly be testifying as to access or control of documents, the only way the government can save such a request for such an act under the Fifth Amendment is to establish facts sufficient to satisfy the Fourth.
Under what circumstances would a request for a document, subpoena for a document, not run afoul of or circumvent the act of production privilege if it's an encrypted document? I think what you're suggesting is that every encrypted document would be subject to the act of production privilege.
Respectfully, no, Your Honor.
So give me an example.
There are two cases from which we distinguish, in which the government cites in their materials to this court that show exactly that. In re Boucher from the District of Vermont and U.S. versus Fracosu from the District of Colorado. In those cases, the government properly introduced evidence tying the defendant in those cases to particular files. In re Boucher, the defendant
with reasonable particularity.
Yes, Your Honor.
Okay. Preponderance of the evidence, you've said. That's the standard.
Yes, Your Honor. In re Boucher, the defendant himself, before the subpoena issued, in properly Mirandized interrogation with an ICE agent, admitted that the laptop was his and decrypted the particular hard drive in question in the ICE agent's presence. So in Boucher, the government already knew that the defendant was capable of decrypting the file. And the same was true in Fracosu. The government introduced evidence in Fracosu based on a recorded telephone conversation that the defendant admitted the laptop was hers, referred to the particular files the government was seeking to have decrypted. So the decision the court would be making today.
If there was no password, if this were not encrypted, would there be an act of production privilege with respect to the contents of that building, the business materials? Somehow the police were not able to access it, but not because of an encryption issue.
In that case, Your Honor, it would still fall under the Fifth Amendment privilege against self-incrimination, because that presumes that only particular people may access a file, even if it's not encrypted. Its access is restricted in some way. I see that my time has elapsed. May I briefly conclude my answer to your question?
Yes. Yes, you may.
So in such a case, that act of decryption and production would still be testimonial. For those reasons, Your Honors, this court should quash the subpoena ducis tecum and reverse the 14th Circuit. Thank you.
Thank you, counsel. We will hear from the government. Ms. Greenlee.
Madam Chief Justice, may it please the court. My name is Mary Sue Greenleaf, and I, along with my co-counsel, Mr. Kevin Cheney, represent the respondent in this matter, the United States government. I will be addressing petitioner's motion to suppress, and Mr. Cheney will address the motion to quash. As petitioners noted, the standard of review on the issues presented today is de novo. The first issue before the court today is whether or not the questions asked during defendant's booking were exempted from the requirements of Miranda under this court's routine booking exception. The questions asked of the defendant merely requested him to identify and state the owner of several pieces of non-contraband property. Therefore, this court should affirm the 14th Circuit and hold that the motion to suppress should be denied for two primary reasons. First, the questions asked were reasonably related to the government's legitimate administrative interest in ensuring accurate identification and storage of inmates' property. And second, the questions posed by Officer Aronson were not designed to elicit an incriminating response.
So what was the record-keeping purpose of asking Mr. Janus, who owned the phone, if it said property of grease monkeys on the sticker on the telephone? The police already knew that.
Well, Your Honor, as evidenced from the fact that Mr. Janus responded to that question by stating that he, in fact, owned the cell phone.
No. The question is, what was the purpose? Is there anything on the record about the purpose of asking a question where the answer seems to me to be self-evident on the phone itself?
Well, the record-keeping purposes would be to ensure accurate identification and inventory of the property.
Well, but Ms.
at
Greenleaf,
issue.
on that, couldn't, as Ms. Gould alluded to at the end of her argument, the government's interests be fully satisfied by an attestation and a voucher form that these are the materials found on me, not necessarily that I own them?
Well, Your Honor, while such a voucher would go a step towards achieving the government's interest in ensuring accurate identification and storage of property, it wouldn't go all the way.
What governmental interest remains unquenched by such a rule?
Well, if you look to page 3 of the record here, the Cortland County Police Department clearly states that the booking procedures put into place by the police department are aimed at ensuring a streamlined booking process that provides clear records of not only who but also what comes through its doors.
Well, so we have the what? We have a phone. It was found on my person. I so certify. Wouldn't that take care of all of the government's concerns?
That would not take care of all of the government's concerns because
Because now I can't use it to prove that he owns it. I got that, okay? But it's legitimate administrative concerns of making sure we have a record of what came through its doors and when and by whom so that we can return it to that individual at the end of the day. Satisfied by my regime? No?
There are circumstances in which property could become mixed up. It may not be that the property that was actually taken off of the defendant's person is the property that's placed into the bag with his name on it that's then stored at the police department.
That's a problem that happens every day, but does that have anything to do with certifying who owns the material versus this was found on me?
Certifying that the materials are found on the defendant would still effectively achieve the showing the connection between the defendant and the phone.
Right.
So it would make
So we're good to go.
any error as
Why
to
did
whether
Officer Harrison do what he did? He didn't need to ask that extra question if what you say is correct.
Well, that would effectively render any sort of error of the lower court in applying any of these tests harmless because the connection was shown through the fact that the property was found on him in addition to the fact that he states that he owns the property. Because of this court's application of the routine booking exception in Pennsylvania versus Muniz, as petitioners noted, the circuits have reached divergent results as to what does and does not constitute a routine booking question that should be within the bounds of that exception. In analyzing whether or not a question asked by a booking officer is within the bounds of the routine booking exception, the proper analysis looks objectively at whether or not it's reasonably related to a legitimate government concern. Petitioner noted multiple times that only biographical questions such as name, height, age, eye color, etc., should be the types of questions that the routine booking exception is designed to allow. However, as this court noted on page 601 of Pennsylvania versus Muniz, the purpose of the routine booking exception wasn't to allow only those questions regarding biographical information, but to permit the asking of questions by booking officers that are made for record-keeping purposes only that serve legitimate administrative purposes. Here, the questions regarding defendants'
But the question is, was it made for only that purpose, which gets you into the second half of the test, that it wasn't designed to elicit incriminating evidence? And isn't there strong indication in this record that it was, given what the officer knew?
No, Your Honor. There's not strong evidence in the record here that the questions were designed to elicit an incriminating response. If you look to, again, page 3 of the record, which details the purposes behind the routine booking procedures put into place by the Cortland County Police Department, it shows that part of that purpose is to ensure accurate identification of the property.
But even if there is, assume we agree with you that there's a legitimate purpose, some administrative purpose, even if there is, that doesn't get you anywhere, does it, if the reason the question was really asked was designed to elicit incriminating evidence?
That would be true if the question was in fact designed or asked with intent to elicit an incriminating response. Here, however, the record is devoid of any evidence to that effect. If you look also to the 14th Circuit's opinion on page 27, it notes...
Shouldn't it be the government's burden to put in evidence that it isn't?
The burden should be on the defendant to show that there was evidence of this intent. And here...
The district court didn't exactly give the defendant an opportunity to do that, did it?
That is correct, Your Honor. The transcript of the hearing on the motion to suppress does indicate that the district court did not make a factual finding as to whether or not the intent did exist or did not exist. However...
So if we were to adopt this objective test or even this subjective test that your adversaries have asked us to adopt, wouldn't the appropriate remedy be to remand for some set of factual findings after a hearing?
That would be one possibility, Your Honor, to remand for further factual findings. However, the court should still deny petitioner's relief sought, which is granting of the motion to suppress, where...
No, I'm not saying that, but remanding would be the appropriate remedy. Send it back, have the district court make the appropriate determination about whether Officer Aronson's conduct satisfied either the objective test or the subjective test.
Well, Your Honor,
Do you agree with that? That's the appropriate
if
remedy.
The objective test is employed and this court does not find that there is no evidence in the record, if there's a question as to whether or not this intent existed, then yes, that would be the appropriate remedy, to remand to the lower court for further factual finding. However, the record here is devoid of any evidence indicating that intent.
Well, there's evidence that this was a narcotic, that the officer was a narcotic officer for 10 years, and wouldn't a reasonably objective narcotic officer be perfectly aware that cell phones are used frequently in the drug trafficking business? We're aware of that from our cases.
Yes, Your Honor. This brings me to my third point. The court should not apply a should-have-known standard that looks at the reasonably objective.
If we looked at, it's not really should have known if we're looking at a totally objective, a reasonable officer would obviously know. It's not should have known, it's what a narcotics officer, a trained narcotics officer knows about the use of cell phones in the drug trade.
Well, Your Honor, the fact that the questions ended up eliciting information that did then turn out to be incriminating and aid in the prosecution of the defendant doesn't render the question as asked itself one that's designed to elicit an incriminating response.
The only reason, just to piggyback on that last question, the only reason that a trained narcotics officer is going to ask that question about a cell phone is to connect Mr. Janus to drug dealing, to possible drug dealing. Is it specifically laid out that you've got to ask in these booking procedures about cell phones in every case? Is there anything in the record that shows that any of these officers ask about cell phones on a routine basis?
No, Your Honor, there's nothing that indicates that they ask about cell phones particularly on a routine basis. There is, however, evidence in the record that it is part of the Corsland County Police Department's routine and standard booking procedures to ask about the property of criminal defendants.
But in this case, there's evidence that Mr. Peters, a corroborated cooperator, at least by then, or maybe not by then, ultimately, said that Mr. Janus used the cell phone for his drug dealing. And Officer Aronson had that information going into the booking process. Is that correct?
There's not evidence in the record that he asked the questions with the intent of eliciting that information for that purpose. Although there is evidence in the record.
What would you look at to establish that kind of intent? I mean, how would you establish that intent? Officer's not going to admit that's why he did it.
Well, Your Honor, if you look to several cases, one which is cited by petitioners, Virgin Moreno, is illustrative of this point. If you see in the course of questioning that an officer is asking a question in a persistent and repeated manner in order to elicit an answer to that question where the defendant is continually denying it, that would be clear evidence of such an
Okay, so it
intent.
has to be repeated or persistent. That's your position.
It wouldn't have to necessarily be repeated or persistent, but
Okay.
that would be evidence of intent.
That's one way of proving intent. How about this? How about the fact that the phone bears a label indicating another owner? How about the fact that you have a trained narcotics officer who knows that phones like this are used in the drug trade? How about the fact that the officer asks the question about ownership when his partner's out of the room and he's supposed to be asking more routine booking questions and deviates from the script at this particular moment? Now, is that repeated, persistent? Maybe not, but is it similar enough that we should take notice of it?
Well, Your Honor, there's no evidence in the record that Officer Aronson actually deviated from the script in any way here. He
Yes,
states
there is. The other officer was asking age, height, and left it, I think it was weight, it was height or weight, and said, excuse me, I got to run to the bathroom. You, Officer Aronson, continue the questioning, and he didn't continue the questioning about one of those 7 questions. He diverted and asked about a cell phone.
Well, if you
I
look
mean, age, weight, height, cell phone ownership, I mean, that just all flows naturally, right?
Well, Your Honor, because if you look again to page 3 of the record, the Quirksland County Police Department's routine booking procedures do indicate an intent to elicit information from criminal defendants about the property that they bring in whenever they are arrested.
Well, it indicates you're supposed to put everything in one bin. It already wasn't a bin, right?
It wasn't a bin, but the record also notes that the purpose of the booking procedures are to ensure clear records of who and what
And how
comes
about
into.
that? I mean, Judge Seymour raised it was already in the bin. Now, he didn't ask about the ownership of anything else in the bin, right?
No, Your Honor.
Just the cell phone, right?
He asked about ownership of every single item in the
Oh, did
bin.
he? Did he ask?
He asked whether or not the defendant owned not only the cell phone, but also a wallet, a $100
Okay.
bill, and a pack of cigarettes.
Okay. Well, good for you.
4 pieces of non-contraband property, which brings me to my final point. Application of the should-have-known standard that's advocated for by the petitioner would render these sorts of routine questions that don't deviate from the script of the police department's routine booking procedures effectively inadmissible in many circumstances and would open the court up to a wave of litigation.
So what are we to make of the line that Judge Seymour alluded to in Muniz, that seems to accept those questions that appear to be designed to elicit incriminating admissions? Are you going to ask us to ignore that as well? And that's our precedent.
No, Your Honor, I'm not asking this court to ignore that footnote. I believe you're referring to footnote 17 in Pennsylvania versus Muniz, which says that questions designed to elicit...
That's exactly the footnote that I was referring to.
Designed to elicit incriminating statements should be disallowed under the routine booking exception. The booking exception is not limitless, and this court should apply a standard that looks at whether or not the question was reasonably related to a legitimate administrative purpose of the government, but also constrain police officers and prevent them from asking questions that are designed to elicit incriminating responses. The questions asked here by Officer Aronson were not the sort that were designed to elicit incriminating responses, and they were reasonably related to the government's legitimate administrative interest in ensuring accurate identification and storage of property. For that reason, this court should affirm the 14th Circuit and deny the petitioner's motion to suppress. Thank you.
Thank you, counsel. Mr. Cheney.
Madam Chief Justice, may it please the court. As my co-counsel noted, my name is Kevin Cheney. Ms. Greenleaf just explained why the defendant's Fifth Amendment rights were not violated when he was asked routine booking questions regarding his property. I will now address why the defendant's Fifth Amendment rights were not violated when he was compelled to produce a decrypted file found on his computer. This court should affirm the 14th Circuit and hold that the defendant's Fifth Amendment rights were not violated for 3 reasons. First, the actual contents of the file found on his computer were created voluntarily prior to the defendant's arrest and are therefore not compelled testimony entitled to any Fifth Amendment protection. Second, the physical act of decrypting the file is not sufficiently testimonial in order to receive Fifth Amendment protection because the limited testimonial aspects of decryption are a foregone conclusion. And finally, because there is no compelling justification to expand the self-incrimination doctrine to the case before the court today. Your Honors, on the first point, that the contents themselves were created prior to the defendant's arrest and are therefore not compelled testimony entitled to any protection. As this court wrote back in 2000 in United States v. Hubble, a person may be required to produce specific documents, even though they contain incriminating assertions of fact or belief, because the creation of the document was not compelled within the meaning of the privilege.
To be fair, I don't think that your colleagues are arguing that the documents themselves are testimonial, but the act of decrypting it is itself testimonial.
Sure, Your Honor.
What do you say about that?
That, Your Honor, would bring me to my second point, that the act of decryption here has limited testimonial value, and the limited testimonial value that it does have is a foregone conclusion. Now, Your Honor,
How are you going to authenticate? Isn't the defendant argues that the fact that he knows the decryption code and is able to decrypt it is what incriminates him. You don't know that. You don't know that he actually produced these documents, or that he controls them until, if he doesn't have the code, he couldn't get in there, right?
that is true, Madam Chief Justice. However, the defendant himself would not have to authenticate these documents at trial because we have a corroborating eyewitness.
I'm not talking about the documents. I'm talking about his control of them. I'm not talking about the words in the documents. I'm talking about his fact that he possesses them and can control access to them.
Right, Chief Justice.
Is that testimonial?
Yes, Mr. Peters actually physically saw the defendant entering the information into the computer. Which
It looks to me like that was about 2 years ago from this record, what Mr. Peters said he saw. People change laptops all the time, right? You don't know this is the same laptop?
Your Honor, that may be true. However, Mr. Peters' evidence in this case has all proven accurate. Mr. Peters said that the information would be found on a cell phone. He detailed the exact methodology for which the defendant in this case sent text messages to his drug mules who were bringing in narcotics into this country. And also, Your Honor—
You say there are not a lot of details. You just said this is how he does it.
He said this is how he does it in a specific format of date, time, and whether or not the tire change was successful.
Fair enough.
This is proven accurate. He also said that he used his automotive store, the Grease Monkey, as you mentioned, Your Honor, to as the location for this narcotics trafficking.
That might be a basis for an arrest right there. I don't know.
A search warrant, Your Honor, was executed at that location and found trace amounts of MDMA in the areas where the corroborator testified that they would be. He also testified that there would be a computer. And when the defendant was pulled over, he had exactly what Mr. Peters said he would: a laptop, a cell phone, drugs, and money.
But to pick up on Chief Justice Seymour's question, isn't it much more powerful for the government to have, in effect, a statement from the defendant introduced that says, in effect, this is an authentic document, I control the document, these are my materials in this laptop, if he produces this document by way of decrypting the documents?
Your Honor, I would concede that it would be slightly more powerful. However, it's not necessary for authentication because of the corroborating eyewitness who watched him use a laptop for his drug dealing activity.
But isn't the government at closing and opening at every chance going to say, particularly if these business materials are incriminating in any way and show that Mr. Janus has got a connection to and runs a drug operation, isn't it going to say, when he produced these documents, ladies and gentlemen of the jury, he provided these documents in response to a subpoena, and the only way that he could have produced those documents is if he had control over them, because only he could have decrypted the specific folder. Isn't that what you're going to argue?
Absolutely, Your Honor, which is exactly what the government argued in United States v. Fisher. When the government was subpoenaing tax documents from the defendants in that case's lawyers, it was the same thing. And this court ruled that if it is a foregone conclusion, that if by a preponderance of the evidence, as opposing counsel conceded, we don't have to prove by a reasonable—
But the foregone conclusion in Fisher was easy because it was produced by an accountant who could authenticate them. That's totally different in this case, isn't it?
Your Honor, I wouldn't say that it's totally different. I would concede that it is easier to authenticate in Fisher. However, as opposing counsel conceded, we simply have to prove by a preponderance of the evidence, reasonable particularity, that he had control, authentication, and that the documents existed. We know the document exists because we can see it on the computer, the business materials file. We have the testimony of Mr.
You don't
Peters.
know that he can access it.
Your Honor, I believe by a preponderance of the evidence, we do know that we can access it in light of all of the other evidence, that it was found in his car while he was driving. He actually took the bag and threw it in the back seat when he was pulled over by the police. He has conceded during routine booking questions that he owns all the other property that was found on him. And along with, further, Your Honor.
Well, he disputes today that it's his laptop.
He does not, in the record, Your Honor, has not ever disputed that it was his laptop. In fact, in filing the motion, which makes this interesting, Your Honor, in the 3 or 4 cases below this court that have ever addressed this issue, at least in the federal realm, each time the defendant actually argued that they were incapable in some instances of decrypting the files on the computers. And here, Your Honor, the defendant never argued that. He never said that it wasn't his laptop. He never said that he didn't have the ability. He just said that he couldn't be compelled under the Fifth Amendment to decrypt these files, which under this court's foregone conclusion doctrine, using a preponderance of the evidence standard, simply is not the case. The fact of the matter is that after the government went to the district court and got a search warrant.
Maybe we should abandon the foregone conclusion exception. You admit that what's being asked of him is testimonial, sort of.
Slightly testimonial, yes.
Slightly testimonial.
Yes, Your Honor.
Sounds testimonial to me. Everybody seems to admit that there's some testimonial aspect of being forced to decrypt for the government, become its agent, its computer expert, and decrypt for you.
Yes, Your Honor.
Why shouldn't we force you to do your own work? Why shouldn't we abandon the foregone conclusion? Why should we make the defendant become the agent of the United States government so that the government can prosecute him more easily? You have encryption experts. We know that.
That is true, Your Honor. However, on the facts on this record,
maybe it's time for us to revisit the foregone conclusion doctrine. I'm not interested in the facts of the record at the moment. I'm asking you a legal question, counsel. Why shouldn't we abandon the foregone conclusion doctrine?
The foregone conclusion doctrine is necessary, especially in this light of increasing encryption in order to maintain the proper.
Is the government's position that it couldn't decrypt this? It lacks the technical capacity to decrypt this?
Absolutely, Your Honor.
Is that a credible representation? Do we have an affidavit from somebody of a credible position in the government saying that you lack the capacity?
No, Your Honor, but we have
we have representations of lawyers and briefs, and I admit I doubt very much you too can decrypt this computer. But I also have my suspicions that somebody in the United States government could.
Well, Your Honor, I would point you to 2 things. First, on page 2 of the record, where the encryption software actually states that it was tested against the best available decryption techniques available to anyone. But also, Your Honor, I would point you to 2000.
So we're supposed to believe something on a shrink wrap advertisement that you get at Office Depot.
Not alone, Justice Gorsuch. If you actually look to 2011 subpoena, a case which actually came out favorably for the defendant, there they were investigating a child pornography ring and found these 5 encrypted laptops and hard drives in the defendant's hotel room. And there, those laptops were turned over to the FBI's forensic investigation teams, at which point they came to the court and said that after trying to decrypt it, it simply proved impossible.
Great. I might leave room for the foregone conclusion there. But why here when you haven't even tried?
Well, Your Honor, the record is silent on whether or not
it's silent on any efforts by the government to decrypt this, right?
Yes, Your Honor. That is correct.
So why should we make you do your homework before we force the defendant to become a witness against himself?
Well, Your Honor, I would argue that he is not being asked to be a witness against himself.
You admit it's sort of testimonial.
Right, to the extent that it is
not.
So
he is sort of being asked to be a witness against himself.
No, Your Honor. The testimonial aspects of the decryption are already known to the government through the authenticating witness.
They don't know he knows the decryption code.
By a preponderance of the evidence, Your Honor, I believe that they do. When taken on a totality of the circumstances.
What is it in the record that shows that you have stated with any reasonable particularity, and that's the test that you embrace, that Mr. Janus is capable of accessing the encryption?
Your Honor, the laptop was found in his possession with corroborating evidence.
Other than the possession of the laptop, what shows us that he's capable of actually decrypting this particular hard drive?
The fact is, Your Honor, that we know that he uses a laptop to store his illegal business materials. The file was found on his computer. We know that during execution of the search warrant that photographs, documents, and emails were all found in the unencrypted version of the computer, and that along with the testimony from Mr. Peters. But again, Your Honor, under preponderance of the evidence, there's no testimony on the other side. There is nothing on the other side of the balancing equation to state that he didn't know. No evidence was offered by opposing counsel or the defendant at trial, at the motions hearing, that he was incapable.
Well, he doesn't have to necessarily. I mean, look, it's ultimately your burden to show that he is capable of decrypting this hard drive. Is that correct?
Yes, Your Honor, by a preponderance of the evidence and reasonable particularity.
And what you're saying is the possession of the hard drive plus what Mr. Peters said 2 years ago, or 2 years from that time, is enough?
Yes, Your Honor, and the files found on his computer and the witness and the defendant never claiming that he could not or it was not his computer. Your Honors, that actually brings me to my third point, with that there is no justification for the expansion of the self-incrimination doctrine to the details before you today. Now, opposing counsel said in his third point that
Why
there
is this
should...
an expansion if he's incriminating himself? I mean, he's clearly incriminating himself.
Well, Your Honor, as you can see in my brief, the use of encryption technology is on the rise. And this court in California v. Byers said that issues of self-incrimination must be resolved in terms of balancing the public need on one hand and the individual claim to constitutional protections on the other. Neither can be taken lightly.
Maybe the government just needs to hire better computer people.
Well, that's exactly the problem, Your Honor. There's no evidence that, and if you look to 2011 subpoena and other cases, also the testimony before the Senate Judiciary Committee.
Last time I read the Fifth Amendment, it didn't talk about balancing tests.
This court's jurisprudence.
It said you have a right not to incriminate yourself, right?
That's true, Your Honor.
Okay.
Yeah, but under this court's precedent, the balancing test has been applied. An analogous
Maybe
case,
it's
Your Honor, I
wrong
would
too. Is it wrong too, possibly?
I would argue no, Your Honor, and I would point you to United States v. Broswell for a analogous situation involving white-collar crime.
I thought since we moved to, in the Sixth Amendment context and in the Fifth Amendment context too, when we distinguish testimonial from non-testimonial acts, we've moved away from balancing, and we've moved toward an absolute categorical rule that if it's testimonial, it's protected.
If it's sufficiently testimonial, yes, Your Honor, that
Sufficiently testimonial. Where do you get that from?
Fisher, Your Honor, and this court's analysis specifically stated that it had to be sufficiently testimonial to be protected by the Fifth Amendment.
But when the government admits it's sort of testimonial, isn't that good enough? Is that not sufficient? How do we determine what's sufficiently testimonial?
Whether there would be a significant fact learned by the government that it wouldn't already have, or whether there had to be a disclosure from the contents of his own mind.
Okay. All right. Why don't we have that here? Assuming you're asking, and you will be using at trial, as one of my colleagues noted over and over again, the individual here produced it after decrypting it. You plan to say that to the jury?
Absolutely, Your Honor.
So why isn't that testimonial?
Because the
Why
government.
isn't that an admission against interest?
Because the government already knows that the defendant was using a laptop to store drug dealing materials.
But isn't it additive to say to the jury, hey, any question about his ownership, any question about his control of this laptop, any question about his involvement in the drug industry is put to rest when he was forced and was able to decrypt the drug trafficking documents? Isn't that additive materially to his guilt?
Madam Chief Justice, I see I'm out of time. May I answer Justice Gorsuch's question?
Yes, you may.
Yes, Your Honor. All of those are true. However, that has never been a part of this court's analysis on the foregone conclusion doctrine. We simply have to prove by a preponderance of the evidence that we already know that this is his laptop and that that is his file and that he's capable of decrypting, which we have here. For those reasons, this court should affirm the 14th Circuit and hold that the defendant's Fifth Amendment rights were not violated when he was compelled to produce a decrypted file on his computer. Thank you.
Thank you, counsel. Some reply?
Your Honors, I have 2 brief points on rebuttal. First, as to the routine booking exception issue, the government concedes that the finding of the cell phone on Mr. Janis's person was sufficient without asking whether Mr. Janis owned the cell phone. And even if this court were to hold that the question regarding Mr. Janis's connection to the cell phone fell within the routine booking exception because it was reasonably related to an administrative concern of law enforcement, it should still be suppressed because it was reasonably likely to elicit an incriminating response. The footnote 14 from Muniz relies on footnote 7 from Innis, which goes on to expand the definition of custodial interrogation.
I thought it was footnote 17. I guess I was wrong. 14.
Footnote 14 from Muniz states the routine booking exception does not extend to booking questions that the police should know are reasonably likely to elicit an incriminating response, Your Honor. And that goes on to expand the definition of custodial interrogation. So this court should rely on the rule from Innis to suppress the question and answer. As for the act of decryption and production, the laptop from the corroborator's statements is not necessarily the same laptop that was found in Mr. Janis's vehicle.
Did you dispute, I mean, there was some colloquy about this. Did you dispute in the district court that the laptop was in his possession?
The record is silent, Your Honor, because it appears that the defendant,
So the
was not
answer is
given.
no.
No, Your Honor.
You did not dispute that.
The defendant was not given the opportunity, according to the soliloquy with the district court judge, Your Honor.
Could have filed an affidavit with his motion.
Yes, Your Honor. However, the record is quite lacking. But the government has had much more information in the case in Fisher, and this case is much more comparable to the case, the 11th Circuit's case in 2011 subpoena. I see my time has elapsed. May I briefly conclude? For those reasons, Your Honor, this court should reverse the holding of the 14th Circuit Court of Appeals, suppress the question and answer relating to the cell phone, and quash the subpoena ducis tecum. Thank you.
Thank you, counsel. Case is submitted, and the court will be temporarily in recess.
All rise. So everybody will please wait around while the judges deliberate in another room. Thank you.
All right, if I could just ask everybody to have a seat, please, for a moment. First, as Mr. Cheney exits, if we could just have a hand for the participants. First, I just wanted to really congratulate the participants. I think that what the very best of sort of experiential learning that you can see is from a demonstration like this. This is what we would call on the sort of spectrum of experiential learning a simulated exercise. So that is not a real exercise before a real court, but that doesn't take away or diminish at all, I think, how serious this argument was. I think you saw that from the judges in their preparation from having read the briefs and read the cases, and from the participants themselves. The participants have written wonderful briefs. Most of those have been posted by the legal writing faculty. I think that these are serious issues that appear in courts, and we all benefit from being able to watch this. So I just really want to thank you all for taking this so seriously and doing such a great job. I also wanted to take a moment really just to thank the distinguished guests that are here. I think there are family members of the participants that we welcome here to the law school. There are past Rothgerber competitors, winners of the Rothgerber competition who are here. We thank them for being here. It's always wonderful to have them back on campus, especially here at this event. I want to also thank some of the friends of the law school. There are participants here at the mini law school program that have also come. We really do appreciate you coming, supporting the law school as well. There are faculty members. We really do appreciate the faculty members who are here. Judge Hartman is here, who preceded me in the experiential learning director position. It's wonderful to have you back here on campus to see some participants that you've known over the years, and we thank you for being here as well. I also wanted to thank the 1Ls for showing up here today, and for the faculty of legal writing for encouraging your students to be here and supplying them the briefs. So I hope that as you are writing your own appellate briefs, which I understand are due imminently on March the 21st, that you were able to glean from having read the briefs or being able to watch these arguments something inspiring for you as you prepare for your first appellate briefs. I have since been, having been here at the law school since 2009, I have taught appellate advocacy as a clinic or a practicum course. And I personally feel that it is such an important and valuable skill. And so I hope that you get that out of your 1L legal writing course. I hope that you go on to want to compete in student competitions, that you go on to wanting to write briefs and do what you just saw some of your colleagues here at the law school do. And so I encourage you to do that. This is going to be followed by a reception after the judges return and give you their verdict on the case. Or if they don't give you the verdict on the case, they will be selecting the best team for this year's competition. So we'd ask that you stay for the reception. It's just going to be in Betcher Hall next door. We want to thank the law firm of Wheeler, Trigg, O'Donnell that has generously sponsored tonight's reception. And we really do encourage you to stick around. It's an opportunity for you to meet other members of the community, those past Rothgerber competitors, some of the individuals from the community and the mini law school, and also to talk to the participants and the judges who have been here for us. With that, I think as far as a teachable moment, I think we've seen really great teachable moments from the arguments. But if anybody has any questions for the participants before the judges come out, I'd welcome a question or two if you'd like to just raise your hand. A question on preparation, question on what they got out of the 1L legal writing to prepare them for student competitions. Each of the members here are part of the Barristers Council, and three of the four, sorry, are members of Barristers Council that have all competed on student competition teams, and so could answer some questions for you if you have questions on that. Yes, sir.
Good afternoon. I'd like to ask any of the contestants, do you believe that forthcoming changes in technology, i.e. in taking the stance of decryption, encryption, and the keys of encryption, decryption, who can do it, who can't do it, is this likely to cause the question that you brought before the court? Do you anticipate it might reappear?
All right, so a question, I hope everybody was able to hear that. So the seriousness of the issue that is implicated here on the decryption encryption issue, which I think really is a very important issue. Curious, we'll start here and then we can go over to the government side to argue for whether you think it's a big concern or not.
I think the answer is unquestionably yes. You're going to see this question come before the Supreme Court possibly more than once because there's a lot of nuance to it. All of the cases that Kevin and I talked about in the decryption realm, In re Boucher and U.S. versus Fricosu and In re 2011 subpoena, and those cases, those are all cases from the last 5 years. And Boucher and Fricosu sort of come down on the opposite side than 2011 subpoena does. So there are really two competing schools of thought about how the Fifth Amendment covers encrypted files. So there's no question in my mind that you'll see it again.
I would agree with Tyler. I think that encryption use is on the rise. I saw a statistic that it doubles almost every year. You can get encryption technology that is pretty much unbreakable. Maybe the NSA can break numbers too, but it's pretty much unbreakable to the standard person for relatively cheap. I do hope that when it comes before the court that they disregard everything I said and rule on Tyler. I definitely think think that it will be an issue for the future as most technology questions.
All right, thank you for the question. Yes.
So all of you've done several competitions now and written multiple briefs and several oral arguments. What is one thing that came up during preparation for this that you wish you had known as a 1L when you were trying to write your first briefs and get ready for your first oral arguments?
Okay, I'll start again. Everyone's pointing at me. I think that probably the biggest thing is that it's never too early to prepare for your oral argument and think about the really hard questions that are going to come in response to the arguments that you're making in your brief. I think it's really easy to write a brief and not think about the counter arguments and the challenges to the points that you're making until you're waiting for oral argument and thinking, oh man, the minute I say this, they're going to ask me this question and I need to figure out a way to distinguish it and get out of it. If you think through that while you're writing your brief and you think through your weakest points and make sure that you're addressing the counter arguments and how to dismiss those counter arguments, then I think it makes your writing a lot stronger. It's something that after I read every brief that I write, I wish I would have included something that I talk about in my oral argument when I have written my brief in the first instance.
I would expand on that. I'm going to give a shout out to Dean Norton since she gave me one the other day on this issue. But I think that one of the most important things you can do is really seek out criticism. So when you're preparing for oral argument or when you're getting your briefs back in that first draft, to really, I wish I as one would have paid more attention to the critiques and really sought out, smart people to poke holes in your argument. Almost every argument is going to have some weaknesses and some holes. And the quicker that you can identify those and start working on ways to mitigate or to at least, offer something else, the alternative, are valuable. And I don't think as a winner I really appreciated that until I started working on the competitive team.
Yes.
Does that make sense?
Yes.
So, in cases like this where nobody was really, as far as I heard, arguing to change the law, how do you react when a judge says, well, shouldn't we just change this law? How do you prepare for that also? Because it didn't seem like either side was arguing that standard wasn't good or should be changed in some way.
Okay. Anybody want to field sort of change the test, really?
Yeah.
That we have there's been a prior test that's been applied. Shouldn't we just abandon that test? And that's the sort of luxury of the Supreme Court. The Supreme Court could make a decision that the test is no longer useful and maybe needs some change.
So there are some cases where a case comes to the Supreme Court and it's a circuit split. So you have a couple circuits going one way and a couple circuits going the other way, and the circuits are applying different tests, and sometimes you have to advocate for one test over the other. So you are asking the Supreme Court to basically make law, because maybe the Supreme Court hasn't addressed that issue before. So in those cases, you want to be able to explain why this test is better, why the administrability is easier for lower courts, things like that. I had a Moot writer argue about the Alien Tort Statute, which only has, at the time, had only one case in the Supreme Court, and that had very little to do with what my issue. So we were basically advocating for what the law should be and what the Supreme Court should adopt in terms of law. So you just have to weigh the different arguments and determine why one test or one law or one rule is easier or better than the other.
It's always tough to ask the court to change any of this precedent. We just recently competed in a national competition in which we were asking the court to abandon one of its previous tests. And I think that's always something that you really need to think through. It's definitely going to be an uphill battle. And I think that you really just need to identify what has changed, either in technology or the facts or in the workings of the tests for why that is necessary. But when in doubt, if you can fit your argument to have you win under the current precedent, that is always preferred. And so going with clear eyes if you're asking the court to abandon or overrule any of its previous decisions.
How about when the court is inviting that they are going to do it? How do you deal with that? You were having to deal with sort of an irascible justice.
I think that you just would want to reiterate, if you want them to keep the test, the reasoning that they originally used for why it's important and why.
All rise.
You may be seated. Well, as usual in these moot court competitions, it's a very difficult decision for us because, in general, the briefs are great and oralists are great. But in the end, we came out slightly in favor of the respondents. And would you like us to make some comments?
Sure. A little bit. You guys want to hear?
You want to go first?
Sure. Well, I was very impressed, but then again, I've been very impressed with most of you for a long time. Kevin, I came at you from left field. Should we get rid of the foregone conclusion? You knew it was coming, right? Should we abandon the foregone conclusion doctrine? I don't think that was fairly called for in the materials, but it's a question that occurred to me because Fisher's 1976. It's before the development of a more categorical approach to testimonial materials, and it struck me that that might be something that the court might well revisit. Sufficiently testimonial. What's that? I mean, but that's Fisher, right? And you had to deal with it, and I thought you did very well in coming out of left field. And Mary Sue, you were about as nice to me as you could possibly be when I didn't know my record. Knowing your record is everything. And so, the lawyer who doesn't know the record as well as the judge, that's the first sign that things are going south. And being able to show the judge you know the record better than he or she does and do it in a nice way is really, really a sign of a great lawyer. Leah, you're always on, and coming up in the rebuttal at the end, you bang through the weak bits that you had to clean up, and you finish strong, and you always do. And Tyler, you're the only one I haven't had in class, but I got to say, I wish I had. Your mastery of the law was remarkable, and you were able to dispute and push back against the questions without being disputatious. And that is the key of being a great appellate advocate. It was a pleasure. Thank you for the privilege.
I thought you were all superb under very difficult circumstances. It was a pretty hot bench. I think it's fair to say, with a lot of questions flying from left field, right field, center field, all over the place. And you handled them with real poise, and there were times we could I think see that you were somewhat surprised by the questions and thought very quickly on your feet, which is a terrific sign in an advocate, particularly people just starting out in the profession. And I all think that you did that. I think that you all did that with real aplomb. And Leah, you had a tough job being the first person up there, but I thought you did a very good job of just keeping your cool. Again, there are a lot of questions coming at you. All of a sudden, 2 or 3 of us are asking about the voucher forms, which was not really part of the record, and asking you, in essence, a series of hypotheticals, and you did well to stick by those hypotheticals. Tyler, you, as was just said, had a real mastery of the record, and this is my own view, think that one of the most important things that certainly at the appellate level, and also at the district court level in federal court, in any court, is the record, just knowledge of the record and mastery of the record. And that's principally what judges will be interested in. To fill in holes in their own knowledge about a particular case, because they'll never have a full mastery of the record in your case on a level that you've got it, and you exhibited that to no end throughout your argument. you even when you conceded things, but you never went too far in conceding things, and I thought that was very, very good of you. Mary Sue, you did a very good job. I thought your ending was very good, and you reminded us of what the government's position was. You answered the questions, again, a lot of questions coming at you about vouchers and so on, and I thought you did well. And Kevin, you also did very well. I don't have much more to add. You dealt with the case law, and Fisher says sufficiently testimonial. That is what it says, and so you made the right concessions, I think, and they're difficult concessions to make. But had you not made the concessions to Justice Gorsuch, Justice Loyer would have picked up on that, and I think you did it, and so I just shut up. And I think that was a wise move. So congratulations to you all. You did really just a great job.
And I agree with all of those comments. I thought you guys were terrific. Let me underscore a couple things. How important it is to make concessions when there's no sense arguing something that you can't argue, that's either not supported by the record or a legal argument that all the cases are against you. So making concessions makes you look very credible with court, and that credibility is extremely important when you're arguing. What I found particularly difficult about this case was the lack of evidence. And, you guys did a terrific job. We kept asking questions about that. Where's the evidence? And that, maybe we shouldn't have granted cert in this case because there's so much
improvidently granted.
There's so much missing that we don't know about that you would really need to know to answer the questions, I think, in this case. Let me make one comment about the briefs, something that I noticed, and I can't be specific and go back and tell you what, but it's always important to respond to arguments that your other side makes that are important. You can't just ignore them. And there were a couple times in these briefs where I noticed that. But overall, the briefs were excellent, and your arguments were, I thought, spectacular. So, thank you. And it was a very difficult decision for us.
But congratulations to all four of you.
If I may, I'd like also a hand for the judges for promised our two out-of-state judges that it was 60-some degrees yesterday. Beautiful.
I don't believe it.
Yes. And that, unfortunately, they're going to make it within that 24-hour window when we're back into winter.
It's 62 degrees in New York City, by the way.
Then you'll probably have freezing rain tomorrow. You go home. But I had written down very, very hot bench. The bench was very hot. Thank you very much for all the preparation, the reading of the briefs, all of the crafting of the questions. It enhances the experience, I know, for the participants, but also for the audience as well. So thank you very much for all the hard work on that. And then I'm going to actually have us just hold questions for the reception. And so if individuals have questions for the judges have been gracious enough to agree to be with us through the reception. So we're going to go ahead and go to the reception. There's a sign-in list for those to get wristbands for alcohol.
Right
It's just a rule here. But please join us for the reception, and thank you again for attending.